Hello, my name is Brianna Schroeder. I'm an attorney at Jansen Agricultural Law LLC, based here in Indianapolis. This is a 10-minute webcast about the Indiana Right to Farm Act. We've only got 10 minutes, so let's get going. Today I'm going to talk briefly about what a nuisance is, how the Right to Farm Act is a defense to that nuisance, and some quick case studies of cases here in Indiana that have interpreted the Right to Farm Act. The Right to Farm Act is a defense to nuisance. Nuisance is a really old idea. Currently, it's codified in the Indiana Code, which says that whatever is injurious to health, indecent, offensive to the senses, or an obstruction to the free use of property, so as to essentially interfere with comfortable enjoyment of life or property, is a nuisance and the subject of an action. So that's the definition of nuisance that we use when we think about the Right to Farm Act. So Indiana's Right to Farm Act is found in Indiana Code 32369. First, we see that the act does not apply if the nuisance that is being claimed results from negligent operations. The act looks long and complicated, but we'll break it down so you can see that it makes sense. The Indiana Right to Farm Act contains a long purpose statement, which is really important. Courts have looked at this statement when interpreting the statute. Right to Farm Act laws encourage farmers to continue devoting their land to agricultural purposes. Right to farm laws also protect investments in farmland for agricultural production. Nuisance complaints objecting to noise, dust, odors, chemical use, slow-moving machinery, things like that, makes farming more difficult and less financially stable. The Indiana Court of Appeals has issued a number of opinions reaffirming this purpose of the Right to Farm Act. My favorite is in Shadow versus McNulty, a 1987 case. There, a neighbor sued a hog farm for nuisance, claiming his residence was affected by odors and flies from the hog farm. The Indiana Court of Appeals dismissed that suit based on the Right to Farm Act and observed that pork production generates odors which cannot be prevented, and so long as the human race consumes pork, someone must tolerate the smell. So let's dig in a little bit and look at the mechanics of the statute. So first, there must be changed conditions in the vicinity of the locality. And that essentially means that non-agricultural uses are encroaching on traditional agricultural land uses. And that's what that part of the statute or the act gets at. Next, the agricultural operation must be in continuous operation for more than a year at the time the alleged nuisance began. This includes the time of predecessors on that property. So it would include the time that I farmed a soybean field before I sold that land to you and you started operating a hog farm. You get to tack the time on. The clock doesn't restart with each owner or new type of operation. Second, we have to ask whether the agricultural operation would have been a nuisance at the time it began. And finally, we look at whether there has been a significant change in the operation. The Right to Farm Act applies as a defense to nuisance lawsuits as long as there has not been a, quote, significant change. Now, the statute tells us that certain things are not considered a, quote, significant change, including the conversion from one type of agricultural operation to another, which includes changing from crop to livestock and back again. Change in size or ownership is not a significant change, and neither is participation in a government program or the use of new technology on the farm. There's a few big cases that have addressed the Right to Farm Act here in Indiana. The act is frequently litigated, and courts have given us some explanations of how the act works in practice. So the first case I like to think of is TDM Farms. that's a case that really focuses on sick pigs. The act doesn't apply between two farming operations. And that's the main holding out of that case. The act is intended to prohibit non agricultural land uses from being the basis of a nuisance suit against an established agricultural operation. So it doesn't apply between two farmers. Another big case addressing the Right to Farm Act is Lindsay versus DeGroot. And there, the Court of Appeals held that there was no significant change when a property went from an old hog farm and crops to a modern dairy farm. Court also noted that the negligent operation would only bar the application of the Right to Farm Act if that negligence was the proximate cause of the nuisance. That's the center of the lawsuit. The next big case is Parker versus Obert's Legacy Dairy. And there, the Court of Appeals held that even when the plaintiff is a hobby farmer, non-agricultural damages that are the source of the complaint means that the TDM farm exception doesn't apply. So the farmer versus farmer exception doesn't apply when the plaintiff is just a hobby farmer and the claim of their damages has nothing to do with their alleged agricultural operations. In Parker, the plaintiff was a hobby farmer, but his complaint of the dairy farm had nothing to do with his hobby farming. It had to do with odors that allegedly affected his residence. In Parker, the Court of Appeals also held that the expansion of an existing dairy onto adjacent cropland that had been used to support the dairy is protected under the Act. Finally, a federal court decision in Dalzell versus Country View. There, the court held that the Right to Farm Act's phrase would not have been a nuisance at the time the agricultural operation began, asks whether the property was historically used for agriculture, not whether a modern confined feeding operation would have been a nuisance many years ago. Like the court in Lindsay, the Dalzell court also noted that negligent operations have to be the cause of the nuisance in order to bar application of the Right to Farm Act. So that's kind of a broad overview of how the Act functions here in Indiana. Based on our litigation experience with the Right to Farm Act, some advice to farmers that I always give is to know the neighbors and communicate with them regarding any plans for expansion or construction, to carefully choose expansion locations with a mind toward the Right to Farm Act and whether it would apply to protect your operations. It's important to avoid negligent operations, and that's for many reasons, not just the Right to Farm Act, also, of course, just for state permitting and operating purposes. And finally, it's important for livestock operations, especially, to buy insurance that protects against nuisance lawsuits. This can help a farmer out down the road if they do face one of these lawsuits, even if the Right to Farm Act ultimately will protect them. So that's today's 10-minute webinar. I hope you enjoyed it. You can contact me at Schroeder at aglaw.us with any questions related to the Right to Farm Act. Please visit our website at aglaw.us for more information. And I hope you return in 2018 for my colleague Todd Jansen's next webcast.